I'd like to establish quorum. Madam Secretary, please call the roll.
Chow.
Here.
Chow here. Wilk.
Present.
Wilk here. Baker. Calderon. Chang. Cooper.
Present.
Cooper here. DeBobne. Gatto. Gordon.
Here.
Gordon here. Lowe.
Here.
Lowe here. Olson.
Here.
Olson here.
All right, then we're going to wait a couple minutes for the witnesses to get here before we start.
Hurry up, man, boy. Okay, thank you. Okay. You know what?
Prospective only on this, so we don't interfere with a lot of contracts with people who are already negotiated.
Okay, yeah, that's
Yeah, a
fine.
couple weeks away.
Yeah.
Oops, shit, I turned this off. Prince died.
Yeah.
Wow.
Yeah, he did, yeah.
Wow.
He did. He did. He did.
He's dead, yeah.
He died, yeah.
So, name 5 songs, Kristen. Name 5 songs.
That counts for 4 because I sung it. I don't know.
That's a good voice, too.
Okay.
I couldn't name 5, I don't think.
So, they got. Yes, we're ready.
Where's my fifth?
Up first, item number 1, AB 1940 by Mr. Cooper. You may proceed.
Thank you for accommodating, Mr. Chair and members. AB 1940 will require law enforcement agencies that deploy body-worn cameras to develop, through collective bargaining processes, policies and procedures on their use, including the recommendation of best practices. AB 1940 will also allow peace officers to view body-worn camera footage before they write reports and give court and internal affairs testimony to ensure accuracy in memory recall. This type of access has been an effective, long-standing practice of other types of video and audio recordings taken by law enforcement in the performance of their duties. With body-worn camera equipment being used by more law enforcement agencies, it is important that they develop a policy to promote transparency and consistency based on best practices which fit the needs of their community. I have accepted amendments from the Public Safety Committee that require supervised review of footage under certain circumstances. I have also accepted this committee's amendments that will mandate body-worn camera policies are available for officers and the public and prohibit the unauthorized duplication of footage. I respectfully ask for your aye vote.
Witnesses in support?
Mr. Chairman, members, Randy Perry with Aaron Reed and Associates on behalf of PORAC sponsors the bill. The only thing I want to state about the bill is I just want to make it clear that PORAC fully supports the use of body cams, and we're just trying to make it so it's fair for the public, fair for witnesses or victims that we record, and that's what we've been working on all year.
Mr. Chair, Member Shane Levine, on behalf of the California Statewide Law Enforcement Association and the Fraternal Order of Police, also in support. We appreciate the work of the Privacy Committee on this bill moving forward. Thank you.
Hey, Mr. Chair, members, Matt Seiberling on behalf of the Association for Los Angeles Deputy Sheriffs, the Los Angeles Police Protective League, the Riverside Sheriff's Association, the Los Angeles County Deputy Probation Officers Union, AFSCME Local 685, and I've also been asked to communicate the support of the Los Angeles County Professional Peace Officers Association, the California Narcotics Officers Association, the College and University Police Chiefs Association, and the California Correctional Supervisors Association, all in support. Thank you.
Any others in support? Okay, any others in opposition?
Morning, Mr. Chair and members. Kevin Baker for the American Civil Liberties Union of California. We don't believe it's prudent policy to have officers reviewing police body camera footage before they make statements. That's contrary to the policies that many departments have currently. And it's not prudent, I think, as the bill itself recognizes, because there's an exception in the bill for serious offenses, right, where there's a use of force. So the bill itself recognizes that that's not prudent policy when there's a serious issue at stake. There are other serious issues involving other misconduct. The bill does not address those. It continues to allow officers to review body-worn footage before they give statements. It's contrary to established policies in other police departments. It's contrary to good police procedure. And the bill itself recognizes that it's not prudent when you've got a serious violation. Uses of force are not the only serious violations. We oppose the bill on that ground. Thank you.
Next witness, please. Seeing and hearing none, let's come back to the committee. Questions, comments from committee members. Ms. Baker, go ahead.
Thank you. First to Mr. Cooper. You mentioned that you have agreed to amendments from the Public Safety Committee. Have they actually been taken yet? Or is that coming after it comes out of this committee?
It's coming after it comes out of this committee.
Okay, so the actual language you've worked out with Public Safety, but it's not before us today.
Correct.
In this committee. Okay.
That just happened on Tuesday.
Okay. And does this language that you have that you're working out, because I do think this is important. We've had a lot this week of, because of the deadline, language we might not actually get to see, but does this, just confirming, it does allow our local communities, for example, my city of Livermore, to have varying policies. These are suggestions, but they can still have their own policy. Can you reiterate the circumstances under which the language you're referring to allows the local community to have a different policy?
They can have different policies, and one of the things a lot of folks don't realize is there are a lot of agencies that have body-worn cameras that have already done this through collective bargaining. LAPD, for instance, their policy is set in stone. This board cannot change the action, this committee or the legislature. So it's set in stone right now. So going forward, this will help some agencies. But right now, agencies can set their own policies outside of this.
In every circumstance, or how does the serious injury, does it mandate in the serious injury area? And again, we don't have all the language before us, so I apologize for sending you down that road, but it is important.
I'll let our authors step in on this, but with part of it, under serious injury or death, before the officer reviews it, it will be viewed with somebody else, internal affairs or a supervisor. He will not view it himself in cases like that. And that's really the big issue.
But can the local community do that? I'm seeing heads nod and shake, so I'm just trying to make sure.
The bill, there are two pieces regarding that issue. There are a list of several things that they shall consider while they bargain, and that's in there.
Saw that.
But regarding the viewing or previewing by the officer, that is an issue that there are the two things that are statewide. We're trying to make statewide that they shall be collectively bargained, which is generally what's happening now, and that the officer can preview in two different situations. They can preview it before writing a report in non-serious use of force situations. And the amendments we took in public safety dealt with the serious use of force, some of it from the Weber bill last year, which said that they shall not preview it until they have a supervisor or an investigator in the room with them.
Okay, and that's
so those are the only two things that are statewide, because we felt that those should be statewide standards. You don't want 3 departments to roll up on a scene. 2 of them, when they're making a report for the DA regarding prosecution, can look at the footage, write the report based on what happened, what was their involvement, and then the third one rolls up at a different time or whatever, is completely can't view anything and is writing it based on what they saw and the time they were there, and they could skew the case. So we thought that it should be a statewide uniform policy.
Okay, thank you. And again, I realize not all the language is before us today. It's going to impact my vote on this here in front of me today. Now, an additional question. This is for the opposition, Mr. Kevin from ACLU.
Mr. Baker, as a matter of fact.
Oh, well, good last name. There's a practice in the court of law, which has evidentiary rules, that if a witness can't remember everything perfectly, they get to refresh their recollection. It's an acknowledgement that human beings are not immediate, precise memory people. At least I am. Can't even say it right. For example, if there's a witness and you're asking them to recall something, you say, well, does taking a look at this refresh your recollection? Would you add to this? City of Livermore, in my district, actually has a policy, if there is a circumstance that I think would fall within this area, that the officer is allowed to, first has to give a state of mind report. So this isn't the police report. This is their state of mind testimony. To capture that as he or she remembers it immediately, then they get to look at the video, and then they're allowed to supplement and say, does this refresh your recollection about anything, just like we do for witnesses. And I'm curious, because you sound like doing any viewing of this is just wrong. It opens to unscrupulousness, but we do it all the time in the court of law. I'd like you to address why that is not perfectly appropriate to refresh a recollection.
Absolutely. Member Baker, thank you for the question. You're absolutely right. We don't have a position that the officers should never be able to review. What this bill says is that they shall be required to or allowed to review before they make any kind of statement. And what's interesting about that is that it singles out only the officer for that kind of special treatment. Nobody else gets to review the footage before they're allowed to make a statement or required to make a statement, witnesses, etc. Right?
Is there anything that precludes that?
Is there anything that precludes?
For example, if somebody tapes it on their phone, is there any reason a witness can't look at that footage before they make a statement to officers?
The question isn't what other evidence. The question is, how are we going to treat body-worn camera footage?
I know. You just raised a point that it doesn't apply to other witnesses. Excuse me. Sorry. It doesn't apply to other witnesses, so I'm just making sure. Currently, right now, a witness can look at footage. There's nothing that bars them from looking at footage that they may have or that other people in the public forum have taken. Is that correct?
If you're suggesting that everybody ought to be able to see body-worn camera footage before they make a statement, that would be a rule that would at least have universal application. What we're doing in this bill is to create a special rule only for officers. Now, we don't have that policy, according to the author, for serious uses of force, right? That's not the policy in the bill. The policy in the bill says if it's a serious use of force, we're not going to let the officer review it ahead of time. So why is that, right? There's a difference in treatment between these two situations.
I see a lot of heads nodding. Right? I think this is important,
but I mean, if you think about it, right, it's not even good police procedure. The reason that we have, for instance, witnesses interviewed separately from one another is because we think that people will tell the truth, most likely if they're afraid that they might be contradicted by other evidence.
I'm not sure if you ever interviewed somebody in a criminal case, but what it comes down to, when I worked the streets back in the day, I took Polaroids of evidence, went back and wrote my report with it. For the last 20 years, in-car cameras, we review in-car camera footage before we write a report. That's been going on for 20 years. Detectives, you bring a suspect downtown to the interview room, there's a camera in there, you interview your suspect, I go back, I review the video footage, I write the report, ATM footage, home footage from a phone. That's how it's been used for a number of years. We continue to use that. I may go to court 6 months from now, having a report. I always read my report to refresh it, and with video footage, be it in-car camera or body-worn, I will review that. It could be 6 months, a year from now, 5 years from now, depending on what it is. You have to refresh your memory, and it's a tool. So it's been in use now for over 20 years with in-car cameras, and they work. It's an effective tool. And back in the day, I even carried a tape recorder in my pocket and tape recorded conversations on a small micro cassette. So this has been used throughout law enforcement. And the reason the amendments were taken for the serious death or injury, that was the amendments that folks wanted with that. Like the ACLU, we sat down with Dr. Weber and addressed some of her concerns, sat down with the ACLU. So this bill is kind of a compilation of facts from everybody. So it's one of those things where everyone's not happy, everyone kind of doesn't like it. So to me, it's the best of every world.
I'm done on this one, but I'm looking forward to seeing the full language, and I think I find that the opponent is actually brushing a little too broadly. We do want to have something that's appropriately tailored to find the unscrupulous people who are out there and who have used force or some official action inappropriately. I'd like to see all of the language to make sure that it is going to be narrowly tailored in that way. I think we can't deny that there might be unscrupulous folks out there, but we also can't deny that officers are in a very unique situation. They're making split-second decisions, and it's important that their state of mind be as accurately documented as possible. And it can be open to cross-examination in a court. The credibility can be undermined, but we want to focus, I think, on the unscrupulous and how to catch them and who's used force or something inappropriately, and not glom on all of the otherwise well-intentioned good actors into the legislation. I'll be laying off because it doesn't have the final language in front of us. I appreciate the author working on it, and those are some of the issues I'll look forward to hearing about as it goes forward.
It's my understanding that the amendments are going to be taken in appropriation, and there is a revised analysis that's been passed out earlier, which basically outlines the changes that are going to go in. Now, let me pose a question. Is it correct that under current law and practice, videos and images captured by dash cams, officers are able to see before they write the report?
Correct.
Okay. Now, the other question I think has been raised is that obviously, there are instances where the officer have to basically, look at the videotape, to refresh their memory before they write the report. And one of my concerns previously was that we don't want the tape to be viewed so that the officer could kind of tailor the story according to what they see on video. So I think one of the things that we suggested was to put some safeguards in there so that they don't utilize the videotape just to kind of tailor their story according to what they see on tape. I think those safeguards are adequate with respect to my view. So I think that's where the balance ought to be struck. So I feel comfortable with the bill, with the amendments. Ms. Gordon, you had a comment.
Just a quick question. I'm trying to get clarification on the authority of a local agency and local jurisdiction around this. And if currently the amendments you're preparing to take are going to say that if it's a non-serious incident, that the officer can review without anyone being present.
Correct.
If a local jurisdiction wanted to say in our jurisdiction, you'd have to have somebody present even if it's non-serious. Could the local jurisdiction do that?
Want me to answer?
Yeah.
Assemblymember Randy Perry with PORAC. Under the current bill, the way it is right now, regarding the preview language, they would not have somebody in there. The officer can allow it. Keep in mind, this bill only says the officer may preview it. So the officer can preview it. The officer can allow somebody in there if they wish to, or they're not even preview it. One thing we are considering, and we just talked about this 5 minutes ago, we're considering amendments in the future, the other house, that would perhaps make this prospective. So anyone who has already negotiated their policy locally, be it exactly what you're talking about, would be grandfathered in.
Okay. Thank you.
Ms. Chang, go ahead.
Thank you. I'm inclined to help move this bill forward today, but I sit on approps, and so I'll be managing or watching the language. I just want to make sure that I get to see the language around managerial discretion before we make a decision on appropriations. And so I'm going to help you out and vote for the bill today.
Thank you. And I'll be honest with you. Right now, if we did nothing, and this bill it didn't happen last year, it doesn't move forward this year, people will still continue to adopt their own policies. So it's happening out there, and it's really a hodgepodge right now. So by us going forward and doing something, at least we begin to adopt a standard. Because otherwise it's happening, and doing nothing helps people in some minds, because law enforcement can pretty much just do whatever they want to adopt. This will set some standard and have accountability.
Thank you very much. I see that several other members have joined us. Are there any further questions or comments from the panel, the committee? Seeing and hearing none, would you like to close?
I respectfully ask for your aye vote.
Madam Secretary? Oh, yeah. Yes. Do we have a motion?
So moved.
Bill's been moved. Do I have a second? Second? Madam Secretary?
The motion is due pass to appropriations. Chow?
Aye.
Chow, aye. Wilk?
Aye.
Wilk, aye. Baker? Baker not voting. Calderon?
Aye.
Calderon, aye. Chang? Chang, I. Cooper.
Aye.
Cooper, I. DeBobne. DeBobne, I. Gatto. Gatto, I. Gordon.
For today, aye.
Gordon, I. Lowe.
Aye.
Lowe, I. Olson. Olson, I.
Your bill is out.
Thank you.
10. 10 votes.
Appreciate you guys taking time to meet.
Absolutely. Got it. We'll be right there. There is one other bill on the agenda, and that is, AB 1820, Quark. That's on unmanned aircraft systems. I believe Mr. Quark is here or was here. Oh, there he is. So this is a vote only, and we're not taking testimony. So at this time, I'd like to entertain a motion to move. Madam Secretary, please call roll.
The motion is due pass to appropriations. Chow.
Aye.
Chow, I. Wilk.
No.
Wilk, no. Baker. Baker, no. Calderon. Calderon, I. Chang. No. Chang, no. Cooper.
No.
Cooper, no. DeBobne. DeBobne, I. Gatto. Gatto, I. Gordon. Gordon, I. Lowe. Lowe, I. Olson. No. Olson, no.
Your bill is out 6-5, I believe, if I'm not mistaken. Congratulations. Thank you. We'll leave the roll open for the next few minutes for add-ons.